In just 31 days, on January 1st, 2026, some of the biggest changes to federal gun laws in decades are going into effect. And if you're not prepared, you could be facing serious legal trouble without even knowing it. I'm talking about ATF rule changes, Supreme Court decisions that just reshaped gun rights across all 50 states, and new federal requirements that could land you with a 10-year prison sentence if you get them wrong. Today, I'm breaking down the 10 new ATF rules and federal gun law changes in 2026 that every single gun owner in America needs to know. Whether you own one firearm or 20, whether you're a new gun owner or you've been carrying for decades, these changes affect you directly. So let's get right into it. Change number 1, NFA tax stamp elimination. Starting January 1st, 2026, the $200 tax stamp fee for NFA items is officially eliminated. This is huge. If you've been waiting to buy a suppressor, a short-barreled rifle, a short-barreled shotgun, or any other weapon, you no longer have to pay that $200 federal tax that's been in place since 1934. Now, here's what you need to understand. The fee is gone, but the registration requirement is not gone. You still have to register these items with the ATF. You still have to go through the background check process. You still have to wait for approval. The only thing changing is you're not paying $200 anymore. And this is critical. If you think you can skip registration just because there's no fee, you're looking at a federal felony. We're talking up to 10 years in federal prison and a $250,000 fine for possessing an unregistered NFA item. The ATF has made it crystal clear that enforcement on unregistered suppressors and SBRs is a top priority going into 2026. So yes, you're saving $200, but you absolutely must still register. Do not skip this step. Change number 2, federal sentencing guidelines already active. This one actually went into effect on November 1st, 2025, but most gun owners have no idea it happened. The federal sentencing guidelines for gun crimes just got massively increased, and this is affecting prosecutions right now. Straw purchases. That's when you buy a gun for someone who legally can't buy one themselves. The penalty just doubled from 5 years to 10 years in federal prison. And here's what's scary. Prosecutors are going after straw purchases harder than ever before. If you buy a gun as a gift for someone, you better make absolutely sure that person is legally allowed to own that firearm. Because if they're not, you're the one going to prison for a decade. Form 4473 violations also got enhanced penalties. If you lie on that form when you're buying a gun, and I mean any lie, even something you think is minor, you're now looking at significantly longer prison time than before November 1st. The ATF is using these new guidelines to send a message. They want gun owners to know that paperwork violations are being treated as serious federal crimes. So when you fill out that 4473, when you're doing any kind of transfer, you need to be absolutely meticulous. One mistake could cost you years of your life. Change number 3, ATF Form 1 digital overhaul. The ATF just completely overhauled the Form 1 process, and this is actually good news for once. Form 1 is what you file when you're making your own NFA item, like building your own short-barreled rifle or suppressor. The big changes. First, they eliminated the CLEO notification requirement. You no longer have to notify your local chief law enforcement officer when you're filing a Form 1. That was always a pain point, especially in areas where your local sheriff or police chief was anti-gun. That's gone now. Second, the ATF now supports digital signatures on Form 1. You can complete the entire process electronically without having to print, sign, scan, and mail anything. This is speeding up approval times significantly. But here's what hasn't changed. You still cannot start building that NFA item until you receive your approval. I've seen people get confused and think that because the process is easier now, they can start construction while they're waiting. No, you build before approval. That's a felony. You wait for that stamp to come back, then you build. The streamlined process is great, but the legal requirements are exactly the same. Don't get ahead of yourself. Change number 4, pistol brace rule officially overturned. The ATF's pistol brace rule has been officially overturned. Pistol braces are no longer classified as stocks that turn your pistol into a short-barreled rifle. This reversal came after massive legal challenges and court rulings that said the ATF overstepped its authority. What this means for you: if you have a pistol with a stabilizing brace, it's legally a pistol again. You don't need to register it as an SBR. You don't need to remove the brace. You don't need to do anything. If you already registered your braced pistol as an SBR during the amnesty amnesty period when the rule was in effect, you have options. You can keep it registered as an SBR if you want, or you can file to have it removed from the registry and go back to treating it as a pistol. Either way is legal now. But here's my advice. Keep documentation of this rule change. Keep proof that pistol braces are legal. Because if you're ever stopped by law enforcement who isn't up to date on current ATF rules, you want to be able to show them that what you have is 100% legal. Don't assume every officer knows about this reversal. Change number 5. Constitutional Concealed Carry Reciprocity Act. H.R. 38, the Constitutional Concealed Carry Reciprocity Act, is pending in Congress right now and has a real chance of passing in 2026. If this passes, it would be the biggest change to concealed carry laws in American history. Here's what it does. If you have a valid concealed carry permit from any state, that permit would be recognized in all 50 states. Right now, reciprocity is a patchwork. Some states honor certain states' permits, some don't. It's confusing. You need apps and maps just to figure out where you can legally carry when you travel. If H.R. 38 passes, that all goes away. Your permit works everywhere, just like your driver's license. Now, there are some important details. You still have to follow the laws of the state you're in. So if you're from Texas and you're visiting California, your Texas permit would allow you to carry in California, but you'd have to follow California's laws about where you can't carry, schools, government buildings, whatever their restrictions are. Also, you still need a permit. This isn't constitutional carry at the federal level. You need a valid permit from your home state, and then that permit gets recognized everywhere else. This hasn't passed yet, but it's got strong support and it's moving through Congress. If you care about this, contact your representatives. Tell them you support H.R. 38. This could fundamentally change how gun owners travel in America. Change number 6. Colorado mandatory firearms safety training. Starting August 1st, 2026, Colorado is requiring mandatory firearms safety training before you can purchase a semi-automatic firearm. This is a state law, but it's significant because Colorado is often a testing ground for gun laws that other states then copy. Here's how it works. Before you can buy any semi-automatic rifle or pistol in Colorado, you have to complete a state-approved firearms safety course. The course costs between $75 and $150. It takes about 4 hours, and you have to renew it every 5 years. The training covers basic firearms safety, Colorado gun laws, safe storage, and you have to demonstrate basic competency at a range. Once you complete it, you get a certificate, and you present that certificate when you go to buy a semi-automatic firearm. Now, there are exemptions. If you have a valid Colorado concealed carry permit, you're exempt because you already did training for that. If you're law enforcement or military, you're exempt. But for everyone else, this is now a requirement. If you live in Colorado and you're planning to buy a semi-automatic firearm in 2026, get this training done early. Don't wait until August 1st because training classes are going to be completely booked. Get it done now, get your certificate, and you're good for 5 years. And if you don't live in Colorado, pay attention to this. Because if this law works the way Colorado wants it to, other blue states are going to copy it. We could see this spread to California, New York, Washington, Oregon. This could become a trend. Change number 7. Kentucky Red Flag Law. Kentucky just passed a red flag law that goes into effect February 1st, 2026. Kentucky is traditionally a very pro-gun state, so this is significant. It shows that red flag laws are spreading even to conservative states. Here's how Kentucky's version works. Family members, household members, or law enforcement can petition a court for an extreme risk protection order, or ERPO. If a judge grants it, you have 24 hours to surrender your firearms to law enforcement or a licensed dealer. The initial order lasts up to 14 days. Then there's a full hearing where you can contest it. If the judge makes it permanent, it can last up to a year, and then it can be renewed. Now, Kentucky's law does have more due process protections than some other states' red flag laws. You get a hearing within 14 days. You have the right to an attorney. There are penalties for false reports, but it's still a red flag law, and it still means your guns can be taken before you're convicted of any crime. If you live in Kentucky, you need to understand how this works. If you're going through a divorce, if you're having family disputes, if you're in any situation where someone might file one of these petitions against you, you need to know your rights. You need to know that you can contest this in court. You need to know that you should probably get an attorney immediately if this happens to you, and document everything. If someone files a false ERPO against you, that's a crime in Kentucky, but you need evidence to prove it was false. So keep records, keep communications, protect yourself legally. Change number 8. Enhanced background check expansions. Multiple states are expanding background check requirements in 2026, and Michigan is leading the way with changes going into effect March 1st, 2026. Michigan is now requiring background checks for all firearm transfers, including private sales. There are very limited exceptions: transfers between immediate family members, temporary transfers for hunting or at a range, things like that. But if you're selling a gun to a friend, to a coworker, to anyone who's not immediate family, you now have to go through a licensed dealer and do a background check. The way it works, you and the buyer go to an FFL together. The FFL runs the background check on the buyer. If they pass, the transfer happens. The FFL charges a fee, usually $25 to $50. If you do a private transfer without going through this process after March 1st, 2026, in Michigan, that's a crime. We're talking misdemeanor charges, potential jail time, and you lose your gun rights. Other states doing similar expansions. Washington is tightening their already strict background check laws. Oregon is closing what they call loopholes. Delaware is adding waiting periods on top of background checks. If you live in any of these states, you need to know your state's specific requirements. Don't assume that because you could do private sales before, you can do them now. Laws are changing fast. Change number 9. Federal safe storage proposals. Continued. My take on this: regardless of whether this becomes federal law, safe storage is just smart. If you have kids in your home, your guns should be secured. Gun safes, trigger locks, biometric safes. There are so many options available now that give you both security and quick access. Don't wait for the government to force you to do something that's already a responsible gun owner practice. But here's where this gets complicated legally. If this federal law passes, the consequences for non-compliance will be severe. We're talking about federal charges, which carry much heavier penalties than state charges. A state-level negligent storage charge might be a misdemeanor. A federal charge under this new law could be a felony with mandatory minimum sentences. And here's what really concerns me about these proposals. The definition of immediate control is vague. Does that mean the gun has to be within arm's reach? In the same room? What if you're sleeping and your gun is on your nightstand? Is that immediate control, or does it need to be locked up? These are questions that won't be answered until people start getting prosecuted, and I don't want you to be the test case. The other issue is enforcement. How would the government even know if you're storing your firearms properly? The answer is they wouldn't know unless something happens. This law would primarily be used as an add-on charge after an incident occurs. So if a minor gets access to your gun and something bad happens, you're not just dealing with the tragedy itself, you're also facing federal criminal charges. Now, some versions of these bills include tax credits for purchasing gun safes and storage devices. If that makes it into the final law, that's at least something positive. A $500 tax credit could cover the cost of a decent gun safe. But don't count on that provision surviving. It might get stripped out during negotiations. If you're a gun owner with children in your home, here's what I recommend you do right now, before any federal law passes. Invest in proper storage. Get a gun safe that meets California DOJ standards. Those are the strictest in the country. So if you meet those, you'll meet any federal standard that passes. For your home defense firearm, consider a biometric quick access safe that mounts to your nightstand. You get security and you get fast access in an emergency. And document your storage setup. Take photos. Keep receipts. If you ever need to prove that you had proper storage in place, you want that evidence ready. Change number 10. Supreme Court ruling on sensitive places. This is the big one. The Supreme Court just issued a landmark ruling in November 2025 that fundamentally changes what states can define as sensitive places where firearms are prohibited. And the impact of this ruling is going to explode across the country throughout 2026. Here's the background. After the Bruin decision in 2022, states like New York, New Jersey, California, and Hawaii responded by massively expanding their lists of so-called sensitive places where guns were banned. New York's law was particularly egregious. They basically said you couldn't carry in any private business unless the business posted a sign explicitly allowing guns. They banned guns in parks, in Times Square, on public transportation, in places of worship unless you had written permission. They were trying to make it so that even though you had a carry permit, there was basically nowhere you could actually carry. Gun rights groups immediately challenged these laws, and those cases worked their way up to the Supreme Court. And the Supreme Court just said, enough, you can't do this. The ruling establishes a very clear standard. For a place to be considered a sensitive place, where the government can ban firearms, there must be a historical tradition of prohibiting firearms in that specific type of location going back to the founding era, or at least to the time when the 14th Amendment was ratified. What does this mean in practice? It means states have to prove that banning guns in a particular location is consistent with America's historical tradition of gun regulation. And for most of these modern sensitive place designations, that historical tradition doesn't exist. Let me give you some examples of what's likely to survive and what's likely to fall under this new standard. What will likely survive? Schools and universities. There's historical precedent for keeping guns out of schools going back to the 1800s. Government buildings like courthouses and legislative chambers. Also historical precedent. Polling places on election day. Some historical support for this. Prisons and jails, obviously. What's likely to fall? Public parks. There's no historical tradition of banning guns in parks. In fact, historically, people carried guns in parks all the time for hunting and self-defense. Public transportation like subways and buses. No historical precedent for banning guns on stagecoaches or trains. Private businesses by default. The Supreme Court made it clear that the government can't force private businesses to be gun-free zones unless the business owner chooses to prohibit guns. Times Square and other public gathering places. No historical support for banning guns in town squares or public gathering areas. The ruling also addressed places of worship specifically. States cannot ban guns in churches, synagogues, mosques, or temples unless the individual house of worship chooses to prohibit them. That's a huge win for people who want to be able to defend themselves and their families during religious services, especially given the rise in attacks on houses of worship in recent years. Now, here's what's going to happen in 2026. Every single one of these sensitive place laws in restrictive states is going to be challenged in court. We're talking about dozens, maybe hundreds of lawsuits. And based on this Supreme Court ruling, most of those challenges are going to succeed. If you live in New York, New Jersey, California, Hawaii, Maryland, Massachusetts, any state with extensive sensitive place restrictions, you need to pay very close attention to the court cases coming out of your state, because the places where you can legally carry are about to expand significantly. But here's my warning, do not jump the gun. Just because the Supreme Court issued this ruling doesn't mean all those state laws are immediately invalid. They have to be struck down by lower courts first. So you cannot just start carrying in places that are currently prohibited and say, but the Supreme Court said. No, you wait for your state's specific laws to be struck down by a court, and then you carry. The legal process takes time. Some of these cases will be resolved quickly, maybe in the first few months of 2026. Others might take a year or more. You need to stay informed about the specific laws in your state and the specific court rulings that affect those laws. Here's what I recommend. Follow the major gun rights organizations that are litigating these cases: the Firearms Policy Coalition, the Second Amendment Foundation, your state's gun rights group. They'll be putting out updates as courts strike down these laws. Sign up for their email lists. Check their websites regularly. That's how you'll know when it's actually legal to carry in places that are currently prohibited. And when these laws do get struck down, understand that private property rights still apply. If a business posts a no-gun sign, you need to respect that in most states. The Supreme Court ruling is about government restrictions, not private property rights. So even after all these sensitive place laws fall, you still need to pay attention to posted signs and private property rules. This Supreme Court ruling is a massive victory for gun rights. It's going to restore carry rights in thousands of locations across the country. But it's also going to create a confusing legal landscape for a while as all these cases work through the courts. Stay informed, be patient, and don't take unnecessary legal risks. So there you have it, 10 new ATF rules and federal gun law changes that are going to reshape the landscape for gun owners in 2026. From the elimination of the NFA tax stamp to the overturning of the pistol brace rule, from enhanced federal sentencing guidelines to safe storage proposals, and from state-level training requirements to a groundbreaking Supreme Court ruling on sensitive places. These are not minor adjustments. These are fundamental shifts in American gun law that will affect every single gun owner in this country. Let me summarize the key action items you need to take right now. Number 1. If you're planning to buy an NFA item like a suppressor or short-barreled rifle, you can save that $200 tax stamp fee starting January 1st, but you absolutely must still register it. Do not skip registration. Number 2. Be meticulous with all your paperwork. With enhanced federal sentencing guidelines already in effect, Form 4473 violations, and straw purchases are being prosecuted harder than ever. One mistake can cost you a decade in federal prison. Number 3. If you have a pistol brace, congratulations, it's legal again. But keep documentation of the rule change in case you encounter law enforcement who isn't up to date. Number 4. Watch H.R. 38, the Constitutional Concealed Carry Reciprocity Act. If it passes, your carry permit will work in all 50 states. Contact your representatives and tell them you support it. Number 5. If you live in Colorado, get your mandatory firearms safety training done before August 1st, 2026. Don't wait until the last minute when classes are booked solid. Number 6. If you live in Kentucky, understand how the new red flag law works. Know your rights, know the process, and if you're in a situation where someone might file an ERPO against you, get an attorney immediately. Number 7. If you live in Michigan or any other state expanding background check requirements, understand that private sales now require going through an FFL. Don't risk criminal charges by doing transfers the old way. Number 8. Invest in proper gun storage, especially if you have children in your home. Don't wait for a federal law to force you to do what's already the responsible thing to do. Number 9. If you live in a state with extensive sensitive place restrictions, follow the court cases challenging those laws. Your carry rights are about to expand, but wait for the legal process to play out before you change your behavior. Number 10. Stay informed. Gun laws are changing faster than ever before. What's legal today might not be legal tomorrow, and what's prohibited today might be legal next month. The bottom line is, 2026 is going to be a year of massive change for gun owners. Some of these changes are victories for gun rights. Some of them are new restrictions. All of them require your attention. Ignorance of the law is never a defense, especially when we're talking about federal felonies with 10-year prison sentences. You cannot afford to be uninformed. You cannot afford to assume that what was legal last year is still legal this year. That's why I created this channel, to break down these complex laws into plain English so you know exactly how to stay safe, legal, and confident as a gun owner. I'm here every week covering federal laws, state-by-state guides, ATF updates, and Supreme Court rulings that affect your rights. If you found this video valuable, please hit that like button and subscribe to Guns Law Guide. Turn on notifications so you don't miss any updates, because I promise you, there will be more changes coming throughout 2026. Your support helps me continue doing this research and bringing you these critical updates. And if you have questions about any of these 10 changes, or if there's another gun law topic you want me to cover in detail, leave a comment below. I read every single comment, and your questions help me figure out what videos to make next. Remember, knowledge is power, especially when it comes to protecting your Second Amendment rights. The more you know about these laws, the better you can navigate them, the better you can advocate for your rights, and the better you can avoid legal problems that could cost you your freedom. Thank you for watching. Stay safe, stay legal, stay informed, and I'll see you in the next video.